So let's talk a little bit about contributory fault as regards helmets. We'll do that for roughly half the talk, and then the other half of the talk will deal with what examination of helmets can show us in terms of the head injury and the prospects of a traumatic brain injury. So contributory negligence as regards helmets. The burden is, of course, on the defendant. If the rider is at fault, then that fault has to have what's known as causative potency. But of course, cycle helmets aren't seatbelts, and they are not motorcycle helmets. And whether the use of a helmet in any particular circumstance would have made a material difference, or to the injury itself, or the extent of the injury, is something which will always be the subject of medical evidence and potentially expert reconstruction evidence relating to helmet and relating to the accident and the fall. That will then move on to whether, in fact, the failure to wear a helmet relates to contributory fault, and the issue there is A, has it made the injury worse? B, has it caused injury at all? And C, if the helmet had been worn and worn properly, would the claimant have either avoided injury or had a much less serious injury? There has not been, to my knowledge, and I've looked at this particular area of law quite closely for the last 15 years, there has not been, certainly in any of the higher courts have been reported, a imposition of a contributory fault deduction for the simple failure to wear a helmet. All the arguments to date have failed on issues of medical causation, and that is, the courts have not been satisfied that the wearing of the helmet would have made the injury any less serious. Now, that may be that the courts are simply sidestepping the issue by falling back on the medical evidence. But given that there is no case at all, the highest, as I say, is Smith against Finch, which indicates that it may well be contributory fault to the failure to wear a helmet. But to say, as the learned editors of the various legal texts have said, that it may well reduce damages and will reduce damages and will probably reduce damages, none of those things are made out on the case law as at the moment. So we don't have any if we don't have any UK case law, do we have any EU case law? A case which is referred to in a number of articles is this case in 2014, where the German federal court overturned a lower court's decision that a deduction of 20% should be made for failure to wear a helmet. And one of the things that the German court was influenced by was the fact that only 11% of urban cyclists in Germany wear a cycle helmet. Now that goes to, for example, what the claimant ought to know or ought not to know when deciding whether or not to wear a helmet, and what the prudent and sensible cyclist might do. I think their thinking is, well, what we'd be suggesting is that 89% of cyclists aren't prudent and sensible, which seems to be a very high percentage.